This talk is on evictions, tenants' rights, and resources. This is Charlie Doughty. I'm the managing attorney at DNA People's Legal Services. Our office is located in Flagstaff.
The presentation today is going to concentrate on the Arizona Residential Landlord and Tenant Act. The Arizona law has a couple different areas of law that will apply to different situations, different circumstances. We're talking specifically about traditional residential landlord-tenant arrangements. As the statute defines rentals of dwelling units, it does not include renting a lot for a mobile home unless the tenant is renting both of the lot and the mobile home. If the tenant owns a mobile home and rents the lot space, that's handled by a different section of Arizona statutes. I've listed, if you're able to navigate through the legislative code, the Arizona Revised Statute citations. The Residential Landlord Tenant Act is located in those subsections listed there. There are a few things that the Act specifically excludes. It does not cover residences in the following. A couple of the highlights that I wanted to mention here: public housing, which we'll talk a little bit more about on the next slide, rent-to-own agreements, hotels, and then specifically, it's not listed and described here, but educational institutions. So if you're living in a college dorm or arguably a residence that's located on Board of Regents land, but being operated by a private organization, the Arizona Residential Landlord and Tenant Act might not apply. Situation where somebody owns their mobile home and rents a space, it is handled and addressed through a different statute. The Arizona Mobile Home Parks and Residential Landlord Tenant Act, cited there. If you have an RV and an RV park, that's addressed by a separate act listed there as well. And then I mentioned, if you have housing authority residents, other public housing programs, they would have their own set of federal regulations that would apply. At the end of the lease can happen if a tenant stops paying rent. The landlord must give the tenant a 5-day notice, a pay or quit notice. You might hear reference to that, to pay what is due or move out. And if that is complied with, if the tenant is able to bring up all of the late fees, all of the rental fees, anything that's due, the lease would automatically continue to operate. There are other situations. This can happen either at the end of an annual term lease or the end of a month-to-month term lease, The party ending a lease does not necessarily have to have a reason to end a lease, but cannot refuse to renew as means of retaliating against a tenant when they assert certain rights. The retaliation situations are very fact-specific. It's difficult to really give too many good examples about that or answer any specific questions. If you feel as though you or somebody that you know is being retaliated against and that their lease is not being renewed because of their exercise or assertion of certain rights, I encourage you to review the statute listed there, or even better, reach out to a housing attorney. It'll depend on the situation. It'll depend partially on the lease and partially on the act itself, but the party ending the lease in a non-renewal, either the tenant or the landlord, must give sufficient notice. Typically, sometimes we'll see built into a lease 60 days need to be given prior to the termination of the lease. So that's usually a full month before the last month's rent would be due. If you want to, for instance, in many situations, if you want to to be out of a residence, for instance, by the end of September, you typically have to give notice 30 days prior to the time that the rent is due in that last month. And that really goes both ways. A landlord typically is not able to say, I want you out by the 30th of the next month. They need to give notice of that 30 days prior to the last month's rent being due. Sometimes we'll be able to work with clients, work with tenants, and negotiate with landlords to end a lease early by agreement. It's very important that this be in writing. It's very important that both parties sign, because that's required, and it's going to be good proof of the mutual termination. In other situations, the lease could end if either a landlord or the tenant broke rules. Typically, we see this on the tenant's end, breaking the rules. If the landlord becomes aware of a breach, of a material or important breach, then the landlord must give the tenant notice of what that is, and they also have to give them 10 days. So, for instance, if they're blocking a fire exit, or if they have a stove that needs to be cleaned because of some kind of emergency situation that could arise out of that, the landlord needs to give the tenant notice of that and an opportunity to fix it. If it happens, if it gets fixed, the tenant can stay. There are situations where it might require that a lease needs to be terminated immediately if there is an important, immediate or irreparable breach of the lease, and the landlord alleges that it's something that cannot be fixed. The tenant remains in the home or the dwelling unit. After the lease ends, the landlord can file an eviction. Part of the lease ending, typically, there are exceptions to this, but we strongly would encourage tenants to be present during their walkthrough and notify the landlord in writing that they wish to attend that. Also would strongly encourage tenants to keep a copy of the move-in checklist, just to make sure that the landlord is using the correct one, the one that was agreed to and signed off on at the beginning or prior to the lease starting. And then also make sure that in order for the tenant to receive as much of their security deposit back as possible, clean the unit as specified in the lease. Sometimes you'll have leases that require a carpet cleaning, arrange that with plenty of time, and then also make sure that the receipt is kept of that. There might need to be a chimney sweep or something like that. Make sure that happens before the end of a lease, and then also make sure that happens before the walkthrough, if that timing will work out. Keep receipts, keep proof that these things happened. Make sure that all of your stuff is out of there as well. So if a tenant abandons the property, the tenant just leaves, the landlord still has some obligations regarding the tenant's belongings. There are a couple different statutes that are relevant to that situation. Those, again, are also pretty highly fact-specific situations that, at least in those second two, can be pretty important to have an attorney review there. The security deposits. Security deposits is another thing that our office will help folks out with. The lease is required or should specify how this can be used, if it's something that could be used for past rent or past monies due. If there are going to be certain amounts that are refundable or non-refundable. After the tenant moves out, the landlord is required to return the security deposit within 14 business days. What we encourage tenants to do is request their deposit back in writing. There is a form on, I know that Community Legal Services, CLS of Arizona, has on their website a Form K that will just check all of the boxes to help a tenant request a deposit back, and then start that 14 business days. Within the 14 business days following a written request, the landlord is supposed to provide a disposition of the deposit and explain what amounts were taken out for what purposes. If at that point the tenant disagrees with the amounts that were deducted, they would have 60 days to dispute the deductions. What we encourage folks to do is send that written dispute letter to their landlord. Make sure that that's preferably certified mail. Hand delivered is acceptable, but can be more difficult to prove up later. If you're disputing the security deposits and you've complied with your side of the statute, a tenant would be able to seek relief, typically in small claims or justice court, depending on the amount that is being sought. Most of these amounts are going to be eligible for small claims, potentially removed to justice court, depending on the involvement of attorneys. For folks that are looking for their own assistance or some of their own guidance, I've found, even as an attorney, that the AZCourtHelp website has been very helpful in especially gathering this information graphically and being able to kind of show this. I've split up one of their PDFs into a couple different forms here. When the notice for non-payment comes in to a tenant, one of three things can happen. The tenant might realize that the writing's on the wall. They're done. They don't need to. They don't need to fight this. They're not able to pay, so they move out. With the pay or quit notice, they decide to quit. At that point, if they've surrendered possession, moved out their possessions, but then also returned keys and actually vacated the premises, eviction action should not be filed. Instead, landlord would likely seek repayment of any due funds or fees through a civil judgment, civil action. If any part of the rent that is owed within the notice is paid and accepted, then the eviction action would not be filed. If the amount, if any lesser amount is offered but not accepted by the landlord, or if the tenant does not make any arrangements to either pay rent or move out, then the landlord would have the ability to file an eviction action. If the amount in controversy is appropriate for justice court, most of these cases, especially pre-pandemic cases, were being filed in justice court based on the jurisdictional limits. But some of them are getting monies that are owed that are into the superior court jurisdictional areas there. What happens at that point? The tenant will be served. We'll talk a little bit more specifically about this. From that point, we're over at this diamond box here. The tenant still has an opportunity to get right with the landlord and pay the full amount. If they're still able to do that prior to the court hearing, then the eviction action should be dismissed. This kind of both of these areas here, once the notice has been received, or even prior to the notice being received, prior to the court hearing, what we still encourage folks to do is have access or get access to the Emergency Rental Assistance Program, the ERAP program through DES. In most of the counties, with the exceptions, I believe, of Maricopa, Pima, and Yuma, the Emergency Rental Assistance Program is being administered through DES. I understand that those counties, that Pima and Maricopa and Yuma, have their own separate websites to help and assist folks. I have been seeing turnaround on the ERAP applications very quickly. We've been seeing it within a matter of days in some circumstances. Either a tenant or a landlord can initiate that and start that process. And I think that that's been helpful. We've seen both landlords and tenants taking advantage of those funds to try to help keep tenants housed. If the tenant is not able to do that in time, the court hearing will go forward. I want to talk about the middle section because this happens more than folks might understand or believe. Many times a tenant might just not show up. They just think that there's no reason for them to be there or that there's no point in them attending. And I think that that's a mistake. I think that if you're able to attend the hearing and potentially negotiate any additional time or negotiate an eviction on your terms, or ask for a little bit more time, you might be in a better situation to attend the hearing than to skip it. If a tenant attends the hearing and denies that they owe that specific amount to the landlord, then there's a trial. If they admit that they owe that amount, then the judgment will be ordered for the landlord. In either of those situations, if they don't show up or they show up and they admit, then at that point, the tenant has another 5 days to move out before they're locked out or forced out through a writ of restitution. That's something that if it's executed and the tenant is locked out, the landlord still has obligations to return the property appropriately. This is the end of the PDF here. What happens kind of at the end if for some reason the judge enters a judgment and after a trial finds that the tenant was right and that they did not owe the money, then the tenant could remain. The landlord has an obligation to keep property and belongings for 14 days. And then I mentioned the other statutes. Non-payment evictions. Again, 5-day notice, the pay or quit is needed to be provided to a tenant. If there is no payment within those 5 days, landlord can file. I've got the specific website listed for the emergency rental assistance program there. When you navigate to that website, it will have links and information for the other counties that are not participating through DES. When the eviction complaint is filed, there are specific requirements that Rule 5 of the Rules of Procedure for Eviction Actions require. There's certain language that needs to be present. There's certain party information, and then there's specific reasons for eviction. It has to describe how and what circumstances and on what timeline the 5-day notice was provided. And then there are additional requirements that must be pled or alleged if the landlord is seeking money damages. If the complaint is seeking money damages, and as you can imagine, they typically are if rent is due, then 5C requires that how often the rent is paid is included, the dates that the payments were due, how much was due, and how much late fees have accrued, whether or not attorney's fees are requested if the person is seeking assistance from an attorney, and if the eviction is only based on non-payment, it also requires that the complaint includes specific language about how a tenant may be able to fix it. Essentially, the pay or quit notice also included in the complaint, with the idea being that at most of these steps, if a landlord gets paid, then the lease is back on and in place. The service of process, the complaint and the summons informing the tenants of when and where to go to court needs to be personally served, or kind of what we refer to sometimes as nailed and mailed. Personally served means that a process server has given the tenant a copy of it and can attest or swear that they have done that. You can also post a notice, post the actual complaint and summons, and then also mail registered mail to the tenant. that needs to be complete 2 days prior to the hearing. At least in our county, what I have seen is that the judges are typically screening this and making sure that the service is complete 2 days prior to the hearing. If it's not, then they'll usually continue that sua sponte on their own. Non-payment eviction complaint, everything that's the papers that are served must include the actual complaint, the copy of the 5-day pay or quit notice that was provided. There's also a residential eviction information sheet, which is referred to in statute in the rules as a form that needs to be provided. A copy of the lease, and then a 6-month accounting of rent that is asked to be paid. At that point, a tenant can file an answer either in writing with a fee, or they can verbally answer at court. Typically, substantive defenses include that, no, I actually paid this off in full. Usually we'll see landlords dismissing that if that's the case. Partial rent was accepted, or they live in subsidized housing and they pay less than what is actually claimed and have made those payments. If those have happened, if any of those situations are present and proven to the court, like I said, usually the landlord would agree to that and dismiss the complaint on their own through their counsel. Otherwise, it could be dismissed with prejudice. Procedural defenses, sometimes if you're not able to win on the facts, you might be able to win on the process. If there has not been a proper notice filed, if there were problems with the substantive requirements or procedural requirements of the complaint, if service was inappropriate or improper, if there's not sufficient documentation, for instance, if a lease is not provided or if accounting is not present, then typically that could be dismissed without prejudice, meaning that a landlord could fix the mistakes and then just refile. Sometimes that will help give somebody more time to either arrange to vacate the premises, or give them more time to come up with the rent. So even though those are kind of technical and sometimes hyper-technical defenses, they still could be of good use to a tenant who needs a little bit more time. This is another section. If a tenant is going to seek to file a counterclaim, in particular, if the premises were not fit and habitable and the rental value had diminished, if they have followed steps required in the act, that's something that could be alleged as a counterclaim, essentially saying, I don't owe you this much rent because the rental value, because of unfit or uninhabitable conditions, has diminished. Or if there are other substantive material violations of the terms of the lease. At that point, this is just a little bit more specific information. The court at the hearing will typically place the landlord or landlord's agent and the tenant under oath, and then ask the tenant whether or not they have any substantive defense or procedural defense. If either they admit or a trial happens and the landlord is found to be correct, the writ of restitution would issue after 5 days. The landlord does not have to apply for that writ and have that issued within 45 days. The landlord does have the discretion to wait to allow a tenant opportunity. They do not have to wait at this point. They have at this stage, they have a judgment against the tenant. But if they're willing or hopeful that a tenant may be able to come up with the money, then they can put off on applying for that writ. There are also specific scenarios in Rule 15 that could allow a tenant to seek relief from a judgment. Some things that might not have been known during the tenant's opportunity to answer the complaint, but came up later. That's again very specific and typically fact driven, and would need to be addressed with close counsel of an attorney. There are also opportunities for landlords or tenants, depending on who's not the prevailing party, to appeal, and that's governed by Rule 17 of the Rules of Procedure, which will then point you to a different section of the rules, depending on where the case started. Resources, AZEvictionHelp.org, I think is a great opportunity for folks to learn more about the process in more detail, in a little bit better organized format as far as graphically speaking, and then also other eviction prevention programs that are available through ADOH and then also DES short-term crisis. And the Southwest Fair Housing Council, that's the website there, the SWFHC. That's typically the referral that we give folks for housing discrimination cases. And if your local legal aid organization is not able to assist, what we do is encourage folks to go to the State Bar of Arizona website and search in their county for folks that practice in the relevant area, and then maybe reach out about free consultations or reduced fee consultations as well. Thanks, everyone.